Looks like we have both sides here present, and you each will have 15 minutes to present your arguments. And Attorney Stahl it is, right?
Yes, Your Honor.
Okay. You will have the ability to save up to 5 minutes for rebuttal if you so choose, since you are representing the appellant. I would remind counsel that we, as a court, have said that you cannot use victims' names, nor can you use the names of children. You must use only the initials or the term victim or children. So other than that, are we both ready to proceed?
I believe so, Your Honor. I'm actually trying to see if I can turn the sound up a little bit. But
Oh, you weren't able to hear us very well?
It's just a little quiet, but I'll definitely find a way to make do, Your Honors. I'm not here to waste the court's time.
Well, we want you to be able to hear. It doesn't serve any purpose if you can't hear.
I think I can. It's just a little bit quiet. Actually, if the court will give me just one moment, I will see if my headphones will make it any easier. My apologies.
No, you're fine.
Was not expecting.
Can you hear us better now?
I have to turn it on the computer. Never used for my phone, so please bear with me for just a very quick moment, Your Honor. Honors.
Okay.
Your Honors, I'm okay on this end, just so you guys are aware.
All right, you show off, Chris.
Well, I try sometimes.
Thanks.
Okay. Are you feeling are you hearing any better?
No, but going to the settings now. If not, I promise I will just make this work.
Okay. Our bailiff has texted me because she is much more computer literate than I am. And she says you can try FN plus F3 to turn up your volume.
I'm sorry?
You can, on your computer.
Oh, something just, whatever I just did made it louder. So.
Okay, well, perfect. All right, that's great.
Technology is wonderful.
Did you hear my prior instructions that you don't use the names of victims or children? Okay. All right. Do you want to save any time for rebuttal?
I would like to save, I'd like approximately 5 minutes, up to 5 minutes.
Yeah, 5 minutes is fine. All right, you may proceed.
May it please the court. Good morning, Your Honors. My name is Richard Stahl. As you're aware, I represent the appellant in this matter, Stephen Dubler. After, I guess, a quick summary of what some of the issues in the case were, as the court saw, there's been, I believe, 5 separate orders that were issued by the trial court in an attempt to finalize this divorce for these folks. The case itself lasted about a year and a half, almost all of which while the parties were separated. After reviewing the court orders and trying to go through the different versions of them, it is our position that the support obligations that were put in place by the trial court were inappropriate, inequitable, and need to be remanded to the trial court for a recalculation. First and foremost, as regards the jurisdiction and the final appealable orders that we have in this case, while admittedly they oftentimes seem procedural in nature, I do believe that when problems exist in these type of situations, that the court should take these into consideration. And what occurred in this case is essentially the court initially set forth 3 separate orders attempting to incorporate all of them. And when it was first appealed, this court sent it back as not a final appealable order for other reasons. The court's response was to issue 2 separate orders, all of which incorporating the 3 prior orders, making for, I guess, easiest said, a bit of confusion, and a more difficult time for the parties to go through and fully comprehend and understand what the actual decision of the trial court was. The trial court was limited in what they were determining to the issues regarding spousal support, as the parties were able to stipulate to the vast majority of the property settlement and the parenting regarding the minor children of this case. But by separating all of these orders, they've made a situation that not only creates problems for the parties and a future court review if necessary, but doing so creates a difference, a conflict with what the appellate courts have said, as I indicated within my brief. The larger issues include some of the omissions and errors that were included here. As indicated in briefs that were filed, I believe by Mr. Opperly as well, the trial court referenced and appeared to utilize financial income factors for the parties well after they separated. And while I understand and my client understands and acknowledges, while the parties were still by law legally married, the issues that arose created a situation that they were separated for a great deal of time. And during that period of time, Mr. Doubler was paying a significant support obligation given what his income was. Suddenly, while the case was pending, Mr. Doubler obtained a better job. And while we understand that that would be generally included in a child support calculation, the spousal support calculations are to be determined based on what the standard of living that the parties had during their marriage was. So given that the parties throughout the marriage were earning roughly $40,000, and I know the specifics are within the brief, they were both within that same spectrum of about $40,000. Yes, his income increased to a level that was closer to or in excess of 100, but even Audra, even Mr. Opperly's clients indicated that or acknowledged that heightened income only occurred after the time of the parties' separation. So at no point during the marriage was he making $100,000. And to take the position, as the trial court did, to utilize that higher number created a situation that required a great deal more spousal support, according to the factors that the trial court utilized. In the same vein, the trial court also set up this spousal support arrangement to require Mr. Doubler to pay approximately 50% of the net equity, or I'm sorry, of the net income between the parties. And such an extraordinarily high percentage has created a completely inequitable situation and an extreme hardship on Mr. Doubler, given the fact that he's only recently made these figures. If he was making $100,000 throughout the marriage, things may be different, but this is a brand new situation. And as the court saw through the prior orders, prior agreements, he also took on the burden of, I believe, $50,000 in marital debt. To do all of that and be set up with a spousal support obligation is that high, made this even more inequitable for the parties.
Counsel,
Yes, Your Honor.
I know you're speaking as though that was an agreed upon, like a stipulation or uncontested, at least, that he didn't earn $100,000 during the marriage. But in reading the briefs, it seems like there might have been some evidence or some dispute that he actually did earn $100,000 during the marriage.
If that was implied at any point, Your Honor, I mean, I guess he began working at these jobs during the year, I believe, 2020. I'm skimming through the brief at this time. it appears that in 2019, by prorating his income, it looks as though he, let me see here, and this is including 2 jobs as well, he would have brought in 2009, $72,000. So we're still well below the $114,000 that the trial court placed in that. That's another $40,000. That's essentially the income that these guys were making while they were married, in addition to what that should have been placed in those calculations.
Thank you. So your response is there is no evidence presented that he made that amount of money during
The $114,000, yes, Your Honor, that is my understanding.
Thank you.
Occurred at the time. And well, I guess let me take this one step back to make sure that my clarification is appropriate. Technically, the parties were still married while the pay case was pending. Our position is that when a trial court is looking towards the standard of living during a marriage, there's an inherent belief that, or inherent assumption that this would include the time that they were living together and treating themselves as a married couple. By the time he started earning the $114,000, they had been separated for some time and continued to be separated thereafter, which makes that additional income, I guess, for lack of better words, to be something that really wasn't a part of the standard of living that the marital couple was privy to because of the timing. So
Counsel, I don't remember, and I apologize if it's in your briefs and I just can't remember, but what did the trial court determine to be the termination date of the marriage?
Well, that's kind of a bit of a problem. One of our, it's referenced in 2 sections in the brief, and I don't mean any disrespect by saying it in that fashion, but in one,
I just can't remember, so that's fine.
but in one portion, we recognize the fact that a retirement account was to be allocated pursuant to the duration of marriage. However, in that section and regarding the property division, I believe it was part of the separation agreement that was proposed or presented to the court. It did not indicate what the duration was. However, on one of the support orders that the court issued, it stated that the termination date of the marriage was October 22nd of 2020. Which I believe was the dates that the folks, yes, it was the date that the parties had their final hearing, which was ultimately done by briefs and stipulations.
So then the separation period, the court did include it
Yes,
as during the marriage.
yes,
So that would be consistent with also then including his income during the separation.
they did. Yes, and that's one of the that is our issue regarding this. But one of the issues regarding the spousal support, because you're looking towards what it was during. It's not necessarily the standard at that point, or the factors that we're referring to is not necessarily income of the parties, although it is. It's the part that refers to the standard of living of the parties, and the parties did not have a standard of living of Mr. Dubler making $114,000 at any time while they were living together. So that's where that's one of that's the basis for that issue that we're bringing forth to the court.
I understand, but I guess my point is the standard that you look at while they're physically together or the termination date of the marriage?
I guess the best way I could answer that is that I don't believe that the statute is 100% clear, because the spousal support obligations pursuant to statute refer to a bunch of factors. There's no mandatory calculation. Yes, that would probably make things a lot easier for all of us, and I think Chris would probably agree with the same. But we're looking at a specific set of factors, and those factors do include income. It does include duration of marriage, and it does include standard of living that the parties had during the course of their marriage. There's additional factors such as the property allocations and things of that nature. But given the discretionary nature and the bland, for lack of better words, language utilized in the statute, we believe that in a situation such as this, regardless of what the court's determination was, the reality is that under no situation were the parties living with that kind of standard of living. And I think that's even further premised upon, or further proven by the fact that there was 2 temporary orders issued during the pendency of this case, neither of which recognize this heightened income that Mr. Doubler had at the time, instead only ordering a temporary child support obligation because he wasn't making those kinds of funds. So this is something that's brand new.
And counsel, you are in your rebuttal time. Do you want to say that, or do you, I know it goes by so quickly, doesn't it?
It always does. And yeah, I will reserve my time, Your Honor.
Thank you. Thank you. All right, then if the appellee is ready, you have a full 15 minutes.
Thank you, Your Honors. May it please the court, Mr. Stahl, I'm Chris Opperly. I represent Ms. Audra Doubler as the appellee today. Your Honors, to briefly discuss the jurisdiction of this court, whether it's a final appealable order, with all due respect to Mr. Stahl's argument. And I will say real brief for this court, neither Mr. Stahl or I were the original attorneys on this case. So we're here somewhat trying to help you justices to kind of wade through some of this stuff that took place down below. In terms of the final appealable order, the court finally issued a nunc-pro-tunc, the very last one, and I don't disagree with Mr. Stahl on, it filed one in May, didn't really kind of incorporate all the documents. This court rightly brought this back. We knew it when we were having some mediation back last year. It came back, the court issued its order. It incorporated everything into an initial December document, did not include a child support guidelines worksheet, and then recognized that made a mistake by not doing that, finally attached a guidelines worksheet to the end. That actually finally finished the document, incorporating all the documents. The only thing it doesn't do is attach one of the documents to the very end, but it incorporates it. So there's no need for this court to send this case entirely back on the premise, hey, we've got to attach this final piece to this final document to have jurisdiction. Looking at the support in that's really the big issue and I think spousal support is the big issue. I think one of the things that counsel is arguing, would have loved to argue if you were counsel down at the trial court, is there's this de facto termination date of marriage in this particular case. But there is no argument with regards, there's no filings on that, not a single filing that there should be a de facto termination date, nor does the trial brief for the appellant that was submitted to the court. There's nothing that indicates an argument for a de facto termination date of marriage. And so the trial court in one of its decisions, I think it's the May 28th of 2021 decision, indicates the date of the marriage, which is June 27th of 2008, October 22 of 2022. Now, we know at the time that the parties are making a little bit more what the parties are making at that point. And there's a separation agreement that's been submitted to this court indicating that both parties have significant debt to pay. There's significant debt to pay between the parties. And so husband earning an additional income. And I'll just talk briefly. Mr. Stahl talks about 2019, husband made $72,000 a year. None of that includes the Air Force money that he would have made. And this is kind of the unfortunate thing. There's no documentation that's submitted by the appellant's trial counsel in the brief. It's a brief that literally states, hey, this is what should happen. We should have this, we should have this, we should have this, we should have this. And not a single exhibit to indicate what husband earned in 2017, 2018, 2019, or what husband was currently earning. No documentation with that, and nothing from the Air Force Reserves that he was also earning as well. He made in 2020 $16,000. If he makes that again in 2019, that puts them really close to about $100,000. So I appreciate the argument. In Appellee's brief, she did present some documentation of what she was earning, and as well as what husband was earning through documentation that the court had. Court had it at its disposal, the ability to make a determination what the parties were actually earning at that time, and then make a determination whether spousal support was appropriate for the duration, the duration of the marriage that the court calculated. Just want to go through, I don't know. That I know there's an argument along the way that I think Mr. Stahl makes in his brief that there was a retroactivity of support at some point. And I think if you take a look at the documents closely, that spousal support wasn't awarded until the effective date, the final effective date of is back in May. And so there wasn't any retroactivity changing a temporary order. It was, here's the final order as of May 28th. The spousal support started when that new order came out. The child support was changed and went up slightly. It was not a significant amount. I don't think enough for this court to send it back. I think I put in my brief that if you told the amount that it went up, we're talking about $600 over the course of 12 months or so. In terms of the spousal support, the court indicated when it was determining the amount of spousal support and the duration of spousal support that it considered all the factors. And it doesn't specifically necessarily list out which factors, but the parties, the trial court would have had the ability to see and to take in consideration the parties' separation agreement, indicating how much debt these parties had in terms of the amount of debt they each were taking on. And I appreciate that that the appellant took a once in a lifetime opportunity, earning $100,000 a year. That helps with his debt. That wouldn't necessarily help with the appellee's debt along the way, especially since that all took place again during the parties' marriage.
Counsel, were they still accruing debt during the separation period?
That's a great question, and that's, be honest, I don't know the answer to that question. I don't know that it doesn't state it out. I don't believe it states it out in the separation agreement that they each were still incurring debt as they were separated. So that, I believe, is probably an unknown to everyone here, unfortunately.
Thank you.
You're welcome. There's some discussion. I think there's some assignments there that include child support. I guess real quick, I don't think that appellant or Mr. Stahl is arguing that the $100,000 we used, the $108,000 that was used for income purposes should be not used for child support. That, I think, is pretty clear moving forward. As I kind of laid out in my brief, that it was probably about $10,000 light, as the court didn't use, the court used Mr. or appellant's statement that he made $6,000 in 2020 from the Air Force Reserves. Wife actually had in her brief a document showing that he made $16,000 through that October date. That probably should have been used. But overall, in terms of what appellee is asking for, certainly isn't asking for this court to send it back based on that $10,000 that wasn't included.
You're saying the appellant is not asking to be sent back on that basis?
I
You're not
apologize.
asking.
Appellee, yes, Ms. Stubler would not be asking for this to be sent back
Mhm.
to the court for the court not utilizing that extra $10,000 shown in the document that mother provided in her trial brief at the time, back in October of 2020. But just kind of pointing out that the court probably could have used an additional $10,000 towards Mr.'s income. Yes, Your Honor.
Well, yeah, no, I was just going to say, because there's other line of cases, obviously, that talk about the fact that the court doesn't include all the income that need to be sent back. So I'm just wondering out loud, I guess, with all this.
I certainly understand, and I guess the court, I guess from this, I don't know that Mr. Stahl or the appellant will want this to necessarily go back for an additional $10,000 to be added for a recalculation on it. I know my client, Ms. Doubler, is not, and we didn't cross appeal on that issue. We could have, but we didn't cross appeal on that issue, asking for that additional $10,000 to be added, Your Honors. Because in fairness, I think agreeing with Mr. Doubler, the appellant, and Mr. Stahl, at some point, this process needs to be done and finalized between the parties, heading back and then eventually coming back and seeing you all again in a year. I don't know is helpful for these parties. Looking at the child support, looking at the child support, I know Mr. Stahl and the appellant had an argument that the spousal support wasn't included in the child support guidelines worksheet. I assume it's probably going to talk about that in some of the rebuttal here, and some of the mandatory requirements. In the grand scheme of things, that got sent back. I don't know that would necessarily make a difference to any changes. If the child support were to be reduced by a certain amount, the spousal support could go up just based on the fact that the court attached to its entry a kind of an analysis indicating all income. Here's what child support would be. Here's what spousal support would be, and here's what the incomes of the parties and after tax dollars coming to the parties would be. And so I think the court did that in its analysis. I don't necessarily have anything else. Oh, I guess in terms of the health insurance, I know that there was a discussion about the health insurance, whether that was put in place or not. There wasn't, again, reviewing the trial briefs of the documents, and I think Mr. Stahl and I would have probably done things radically different if we had been the ones providing these documents. We weren't there, and neither one really provided to the court what should happen with health insurance. And so the court did what it's supposed to do, pursuant to revised code 3119-30B, that the child support obligee, that's Mrs. Doubler or the appellee, is required to be the health insurance provider. Finally, I always appreciate unique arguments that are made, and I think the final argument, the assignment of error in 14, I certainly get what Mr. Stahl is indicating, but the parties had an absolute opportunity to try to work through this and try to settle this case. And they did not. They turned it over to the court to make a determination, and the court weighed it at that point and made a determination of what support should be. And in this case, it was more maybe than what Ms. Doubler was asking for, as she put in the briefs. And so that's always a risk when you leave things up for a court to make a determination of what should take place. Your Honors, unless anyone has any other questions, and I've got about 2 minutes, but I don't necessarily have anything else unless anyone has any questions. And we'd like this court to take that into consideration and deny Mr. Doubler's assignments of errors.
Thank you. It doesn't look like anybody has any other questions. Mr. Stahl, you actually have just 3 minutes remaining because I let you go over a little bit longer into your rebuttal time. But I wanted to apologize to council and my colleagues. Downtown Akron seems to be very busy here this morning, and I don't know if you heard the sirens and stuff, but and it's okay, that's good then. And then I'm moving around so much because I twisted my back, so I don't mean to be I don't mean to be roaming all over the place in my chair. So and I hope it didn't distract anybody. Anyway, you have 3 minutes left, Mr. Stahl.
All right, here goes. I guess I will start with trying to get at least a brief summary of the child support, and then attempt to respond to some of Mr. Opperly's positions here. But as he indicated to some extent, the trial court with regard to child support did fail to address a number of issues. As he mentioned, there was a failure to include credit for spousal support, which when doing that through the child support guidelines actually adds income to, or would add income to, Miss Doubler and reduce the income of Mr. Doubler, which would inherently make a difference within the child support guidelines. As I can't necessarily disagree with Mr. Opperly in part in his assertions that these isolated changes may not make a world of difference. But as he referenced the word maybe and we don't know and things like that, we don't know, and that's part of the problem that we were faced with here. Additionally, under the newer version of the statute that was in place at this time, there's also a mandatory 10% deviation for individuals who have more than 90 overnights per year. Mr. and Mrs. Doubler have equal parenting time, which obviously implies more than 90. So that's a mandatory situation under 3119.051. Additionally, the court, if there is parenting time in excess of 147 overnights per year, the court is essentially supposed to, however, if they don't, they are required to specify a rational basis for not doing so. The court is issued orders did not include any basis for not giving that additional deviation. The health insurance issue was obviously present, and as Mr. Opperly referenced, that was, I believe, inappropriately put in there. Sorry, I had my own timer here and it was a little early. We also had the regular old deviation factors that have been in the statute for years and years and years, and none of those were ever taken into consideration, again, for two people who had equal parenting time. When you take all of those factors together, I would believe that there's obviously a portion of the support obligations, child support and potentially spousal support, that would be changed or would be these changes, these requirements, had they been adhered to, would collectively likely reduce the spousal support obligation or change it in general, which is something that the trial court is equipped to do and is the appropriate method or the appropriate level of court to make these determinations. While this court is simply here to determine whether there's an error, the trial court's the ones who run the numbers. And I think that is why we have filed this brief asking for that to be done. Finally, I guess with regard to, as Mr. Opperly referenced, the last portion, courts have said in this district as well as other districts that asking for a number and the court giving you more is inappropriate. I personally know I was involved in the Coletta decision that I cited here, and when the party was asking for, the obligor was asking for an amount less than they were ultimately given, I know that court determined that was improper because you aren't to give more than one request in a situation.
And counsel, your time is up.
Okay, well, with that, respectfully, your honors, I guess unless there was a last minute question, I thank you for your time and respectfully request a remand on this decision.
The court appreciates your arguments and we'll take the matter under advisement and we'll issue a written opinion, and that will be sent to both sides as well as it will be released on the Ohio Supreme Court website. I wanted to address just one issue before we sign off, counsel. One of you mentioned that you had done mediation, I think early on when the first appeal was filed. Has there been any mediation attempted with our court after the second appeal was filed?
If I recall correctly, and Chris, feel free to let me know. I know it was talked about. We may have had one of the mediation calls off the top of my head. It's been a little bit of time. Chris and I have spoken, but
Well, you don't have to get into detail. I just wanted to know. The reason why I'm asking is because both sides seem to have mentioned that there are particular issues that were unresolved by the trial court or something. And I just want to let you guys know that we have a wonderful mediation program.
You know,
And it's still available.
Your Honor, we did the first time around, and I think probably because we were so far away from each other the first time that we just went through this process on the second time through the appeal.
Well, thank you.
I think is what. So, but I
Thank
appreciate that, Your
we
Honor.
both appreciated the mediation program. I know I'm speaking. I think I'm speaking for Chris and saying that they did a great job.
Okay,
Tried everything under the sun.
Well, we appreciate that. Okay, so then our next oral argument date will be November 10th, and it will be in person in Wayne County. So gentlemen, enjoy the rest of your day, please.
Thank you, Your Honors.
Thank you, Your
All
Honor.
right, the court is adjourned.